What's up, guys? So we're here at the courthouse in Fresno, California, at the federal courthouse. I think the attorneys for the plaintiffs did an outstanding job, kind of showing proof that the Border Patrol, were in their tactics, they were unlawful. They were violating Fourth Amendment rights. And as a matter of fact, as you guys have been able to see, if you guys have been following us long enough, my son, Nate Skates, who's actually behind the camera right now, shout out Nate Skates from 82, and myself, we arrived on scene and we were able to record what was happening out there. And it's undeniable that these agents were violating the Fourth Amendment rights of the people. As soon as we arrived on scene, we asked for a PIO. After the PIO arrived on scene, I started asking him questions regarding the Constitution, the amendments. And he started to fumble his words. He didn't know what to say. Goes to show that we have actual proof that the Constitution and the amendments can work in your favor if you know how to use them, if you know how to apply them. And also, don't forget that the camera is the equalizer. It's a preliminary injunction. The ACLU is here on behalf of the plaintiffs, talking about Operation Return to Sender, about the January raids that were happening in Kern County. The plaintiffs raise an argument regarding the character of the past violations, the car stops, the windows smashed, tires slashed. People are forced to answer questions, basically asking if the defense will acknowledge the wrongdoings, constitutional violations, and the defense responds immediately. They claim mootness. They deny that they planned to violate the Fourth Amendment of the people, and it raises questions of whether FLETC trains Border Patrol on the Fourth Amendment. So that was brought up a lot by the judge regarding FLETC, which is the training at the Border Patrol, right? Do they actually train in the Fourth Amendment? We're gonna actually try to request the training from the Border Patrol to see if we could find that in there, okay? They talk about there's 900 agents. So the judge asks how Border Patrol training is going. Agents cannot stop people because of color. Judge doesn't believe training will fix the issue. These are things that the judge said inside, folks. The judge is basically questioning what they were doing. She even mentions Home Depot field worker raids where they were going out there and they were just conducting traffic stops on people. The defense asks what the remedy could be. Defense acknowledges court disagrees with them, claim they want to provide a remedy, right? So basically, it almost seems like they're not denying the fact that these things happen. They're denying that the plaintiffs bring proof of that. But the judge says that the evidence of Fourth Amendment violations happen, and the defense does not deny this. The judge makes a statement that the law is clear, Fourth Amendment, lack of training is not even an excuse, folks. The plaintiffs are asking that the injunction should be granted, asking for a court order to ensure compliance, says without injunction, agents will continue these violations. The judge agrees with the plaintiffs that future conduct should be considered. The judge raises questions regarding jurisdiction. The plaintiffs address questions regarding class certification. Gonzalez versus ICE is brought up. The defense claims that the plaintiffs do not raise proof of discrimination, and the judge questions the defense claims. The defense says the allegations are not evidential, but the judge disagrees. The judge asks, why do you think the evidence is insufficient? Defense says, they're desperate claims by individuals. Who has the info regarding reports of incidents? So basically the judge is asking the defense, where is the reports of the incidents by the Border Patrol agents? Where is their proof that they conducted themselves in a proper way? Whereas the plaintiffs have brought testimony from the people of what has happened. But see, the problem is the Border Patrol, they're not recording these incidents. And even if they are recording them, they're basically saying that they don't have to give proof of what they're doing out there in the field, right? What I seen in there, the defense for the Border Patrol, they did seem to get smacked around in there. The judge did say that she does feel that the plaintiffs did bring proof enough.
Hi, my name is Bree Bernwenger. I'm an attorney with the ACLU of Northern California. So today, the plaintiffs in the United Farm Workers v. Nome case argued our motion for preliminary injunction and motion for provisional class certification. What that means in plain English is we moved for preliminary relief. We are asking the judge to enter a preliminary order while the case is pending that will prohibit Border Patrol from engaging in the same kinds of unlawful stops and arrests that we saw in and around Kern County in January. And the class certification part of that is we're asking the judge to make sure that that relief covers this entire district, the Eastern District of California, which includes all of the Central Valley. I'm very hopeful. I think one of the most powerful things we saw in court today is that the government did not dispute that people were pulled over for no reason other than the color of their skin, that people were grabbed in parking lots for no reason, and that there was no evaluation of whether someone was likely to flee before they were arrested. The plaintiffs in this case put forward a number of stories about the way that they were mistreated during the raids, and the government just has not disputed them. So we think that made a very powerful showing, and we're really hopeful that it's persuaded the judge that she should order relief and not just trust Border Patrol that they've got it now. We're looking for what we call in the law forward-looking relief. We're looking to make sure that when Border Patrol comes up to the Eastern District and wants to conduct an operation in the future, that they follow the Fourth Amendment and federal law, which puts some restraints on what they can do. You can't just pull someone over because they're brown. You can't pull someone over because they look like a farm worker. You can't assume that those characteristics mean someone's violating an immigration law. That's just been the law for decades. And today the court recognized that, and that was very encouraging.